Hello, friend. Welcome to UK Breaking News. There are topics most of us prefer not to think about, and I understand that completely, but there are things that need to be known even if they are uncomfortable to talk about. And what I'm going to cover today is one of them. Because if you have a bank account in your name right now, there is a very real chance that if you died tonight, your family could not access a single pound of that money. Not tomorrow, not next week. Not without a process that takes months and costs thousands of pounds. A will would not help them at the bank counter. A solicitor's letter would not help them. And nobody in the system is going to explain this to you in advance. Today, I want to walk you through calmly and clearly exactly what happens to your money when you die in the United Kingdom, and the one straightforward thing you can do this week while everything is fine to make sure your family is protected when the time comes. Before we get into it, subscribe to this channel and turn on the bell. This kind of practical information is the reason this channel exists. Things that matter explained before it is too late to act on them. Subscribe now and let us get into it. Let me start with a story because the legal framework I'm about to explain is easier to understand when you see what it looks like in practice. Margaret was 73 years old. She was a retired school teacher from Leicester who had spent 35 years in the classroom and saved carefully throughout her working life. She had £180,000 in a savings account at her local bank, the same branch she had used for over 30 years. She had a professionally drafted will properly witnessed and stored in a folder with her important documents clearly naming her two adult sons as equal beneficiaries. She had told both of them where to find it. She believed everything was in order. It was not. Margaret died suddenly. Her sons came to the bank with the death certificate and the will. The branch manager explained as clearly as she could that the will had no authority over the account. The account was in Margaret's sole name. The bank had a legal obligation to freeze it immediately upon notification of her death. No transactions were possible. No money could be released. Not for the funeral, not for immediate expenses, not for anything until the estate had been formally administered through the probate process. The funeral invoice arrived for £4,800. The sons paid it on their credit cards. The interest started running that same week. Margaret's £180,000 sat 20 feet away behind a counter her sons had no legal authority to cross. What happened next was the probate process. Applications to the probate registry, certified copies of the death certificate, court fees, a mandatory waiting period to allow unknown creditors to come forward. From the date of death to the date the sons were finally able to access and distribute their mother's money took 11 months. The total costs consumed over £8,000 of the estate before a single pound reached either of them. Margaret did nothing wrong. She had the will, the solicitor, the documents. None of it reached inside the bank's legal framework. Her situation was not unusual. It was the entirely predictable result of a system working exactly as it was designed to work. Here's the legal framework that explains why. When someone dies in the United Kingdom, any account held solely in the deceased's name is frozen by the bank immediately upon notification of the death. This is a legal obligation on the bank, not a policy choice. The account stays frozen until the estate is formally administered, which means either obtaining a grant of probate if there is a will or letters of administration if there is not. That process, currently running at an average of 6 to 12 months, must be completed before the bank will release a single pound of an account above its threshold. Most major UK banks, Barclays, Lloyds, Halifax, Santander Nationwide, will release funds without probate for account balances below £50,000. For accounts above that threshold, a grant of probate or letters of administration is required with no exceptions. NatWest and HSBC assess each case individually and do not publish a fixed figure. If your savings account holds more than £50,000, your family will almost certainly need to go through the full probate process before they can access the money. And a will does not change this. The will is a document addressed to a probate judge. It instructs the court on how to distribute the estate after the probate process has run its course. It has no legal authority at a bank counter. The bank's obligation runs to the account contract, and if that contract holds only one name, the bank cannot act on a will, however clear and however carefully drafted. There are three specific situations that put families into this position. The first is a sole account with no joint holder. This is the situation Margaret was in. You opened the account years ago. Nobody suggested adding another person. Your will covers everything. It does not cover the bank account because the bank account is governed by a contract, not a will. The second is the assumption that a lasting power of attorney covers the situation. Many people who have arranged an LPA for financial decisions believe that this gives their chosen person the authority to access accounts after death. It does not. An LPA exists to allow someone to manage your affairs while you are alive. The moment you die, the LPA ceases to have any legal effect. The attorney named in your LPA has no more authority over your bank account after your death than a complete stranger. The third is the assumption that marriage automatically transfers bank accounts. In the United Kingdom, marriage does not establish automatic joint ownership of financial accounts. Joint-teney with right of survivorship, the legal arrangement that does allow automatic transfer, must be specifically set up and documented at the bank. A couple who have been married for 40 years and always assumed their accounts would simply pass to each other may find when the moment comes that the assumption was wrong. Here is what actually works. A joint account held as joint tenants with right of survivorship passes automatically to the surviving account holder on death. The surviving holder provides the bank with a death certificate. The bank transfers the account into the sole name of the survivor. No probate required, no court, no waiting, no solicitor fees. The transfer happens in days, not months. This is the arrangement that most couples should be using for their primary current and savings accounts, and many are not because nobody asks them to set it up when they open the account. There is one consideration to understand. The moment you add another person as a joint account holder, they have full legal access to the money right now while you are still alive. If your chosen joint holder has financial difficulties, debts, a divorce, a judgment against them, the account could in theory be accessible by their creditors. For a spouse in a stable relationship, this risk is generally well understood and accepted. For an adult child, the risk is more variable. The decision should be made consciously, not by default. For amounts in sole accounts that cannot easily be restructured, a recent inheritance, proceeds from a property sale, the practical step is to make sure your family knows where each account is held and what the approximate balance is. Most banks will release a specific amount before probate to pay funeral expenses, typically up to £5,000 on presentation of the funeral director's invoice and a death certificate. This does not unlock the account. It is a specific provision to cover the most immediate practical need for notifying banks. There is a free service called the Death Notification Service, which allows a single notification to reach Barclays, HSBC, Lloyds, NatWest, Santander, Nationwide, and Shawbrook simultaneously, reducing the number of individual calls your family has to make in the first days after your death. It can be accessed at deathnotificationservice.co.uk. For government departments, tell us once available through gov.uk or via the registrar when the death is registered. Notifies HMRC, the DWP, the Passport Office, and the DVLA in a single step. So here is what to do this week. Look at your bank accounts and identify which ones are held in your sole name. For each sole account, consider whether adding your spouse or partner as a joint holder with right of survivorship makes sense for your situation. If it does, ask your bank about converting the account or opening a new joint account. Make sure your family knows where your accounts are held and has the deathnotificationservice.co.uk address with your important documents. And if you have a lasting power of attorney in place, make sure the person named in it understands clearly that their authority ends at the moment of your death. Your will is important. Your solicitor is important. Your estate plan is important. None of them reach inside a bank contract. The structure of your bank accounts, whether they are held solely or jointly, is the thing that determines whether your family walks out of a bank with access to your money or whether they spend the next 12 months and thousands of pounds going through a process that could have been avoided entirely. Subscribe. Share this with someone you know who has a bank account in their sole name. I will see you in the next